Father, we come before you, Lord. We adore you. We respect you, King of Kings, Lord of Lords. We put you before this class. Give me wisdom to be able, God, to dispense to conduct this class. I pray, God, for the participant, Miriam. Remember her in her exams as we prepare in the next 2 weeks. With her, guide her in preparation and the exams day time and marking and the results. When the results are announced in January 2024, all the glory shall be yours after we discover she has gotten 9 P's. Remember the sacrifice she have made. We pray, God, for all the subscribers and people who have purchased the papers on the website. I thank you, God, because of them. The people who have engaged me privately, give me feedback. Remember them, give me more purchases and subscription and views in my website and my YouTube channel as the exam nears. Let the materials that is there to help the preparation, both for the regular and recent candidates. I pray all this believing in Jesus Christ, my Lord and Savior. Amen. So, we are going, I welcome you to Criminal Drafting Part 5. We have taken a break a bit, but now we are back. We are on questions that have been captured in topic 12 to 20 of the course outline, and I think criminal litigation will be the only the subject that we will be able to substantively deal with the draftings. So it is very, very important if you are doing criminal litigation, you look at this. You look at this uploads YouTube. So topic 12, as you can see on the screen, we are on appellate jurisdiction. Then there is specialized. We have a question on private prosecution, inquest, extraditions, habeas corpus, and then judicial review. And we will be done. For this class, for purposes of this class, we are going to deal with these 3 questions. Question 1, 2, and 3. Then the next class on Thursday, we are going to deal with question 4, 5, and 6, and 7, which are on your screen. Question 1. Question 1, it was question 6B of November 2011, which is showing on your screen, which I don't need to read. No, question 6B, November 2011, which I want to now to go there. So I'm going to read the question. This is question 6B, November 2011, or the question 6, because Miriam did the question, the complete question. We are going to look at it. So question 6, November 2011, Alibaba, a renowned saxophonist and guitarist, has recently established a musical school for training children aged 14 to 17 on how to play a piano, guitar, a saxophone, and other musical instrument. Alibaba is age 44 and is not married. He set up a musical school within the residence in Kuma and merely converted one of his guest house to be a training center. Occasionally at the music lesson, he would invite trainees to assuming lessons and he would invite them to substantial dinner when they would engage in lively discussion on what it takes to become a musician. It transferred that in course of the training, he developed an emotional attachment to Lisa and Belly, who were his favorite students. They were both 15 and 16 respectively. Lisa and Bella attended Kianda School and would attend the musical lesson every evening. It was agreed between Alibaba and their parents that he would always drop them in their respective homes. It turned out that the course of private lesson, Alibaba took advantage of the ignorance, naivety, and innocence of young girls and ruled them to have sexual intercourse in the car. So until to that point, there was no crime committed. So having sexual intercourse with girls who are not, the law deems them to not to have power to consent. So, of course, the issue of defilement is coming up. He apparently infected them with herpes, a sexual transmitted infections. This came to light when the young girls complained to the parents about their medical condition. That's another crime. Infecting them with sexual transmitted infections. They came to light when the young girls complained to the parents about their medical condition. The doctor's report revealed a nature of infections which prompted the parents of Bella and Liz to lodge a complaint at Milimani police station. Alibaba was arrested and charged with offense of defilement contrary to Section 8 and 2 of the Sexual Offences Act 2006. During the trial, the evidence was led that Alibaba ruled the minors to have sexual intercourse with him against their wish, and parents testified to the effect that they were informed by their daughters on what transpired, in effect corroborating the testimony of the complainant. The medical doctor gave evidence as to the source and nature of sexual transmitted diseases. There was no evidence that was led as to the age of the complainant during cross-examination of an officer from the Children's Department. He was at pains to tell the age of the complainant. During cross-examination of the complainant, it turned out that Bella was 14 and Liz was 17, contrary to what indicated in the charge sheet. The charge sheet is reflected ages 18 and 16 respectively. At this juncture, no attempt was made to amend the charge sheet. At course of the prosecution case, the Honorable Magistrate Deila Omondi found that the accused person had a case warrant and was put to his defense. He elected to remain silent, and the court eventually found him guilty of the offense of defilement. When delivering the judgment, Honorable Omondi unilaterally amended the charge sheet to reflect the defilement contrary to Section 3 of the Sexual Offences Act, which prescribes a punishment of not more than 15 years imprisonment, and having had the mitigation, namely that the Alibaba suffers from prostate cancer and attends to chemotherapy on weekly basis at temperature, proceeded to sentence him to 20 years imprisonment. Alibaba is naturally aggrieved by unfolding events that have instructed the firm of Cliff and Allen, a renowned criminal litigation firm to which you have been recently recruited as junior associate. The head of litigation has assigned you Alibaba's brief and seeks legal opinion on the way forward. So prepare the relevant documents to be read in court. So of course, the legal opinion, is connected to, your client is as Alibaba. So your legal opinion is, of course, is on how you are going to attack the proceedings in court. And then question B, is on relevant document to be rearranged in court. So the question is 15 marks, which according to the rules I told you, you are supposed to, for a question of 50 marks, you are supposed to use question of 20 marks, you use 50 minutes. That is the compulsory question. Question of 15 marks, you used 38 minutes. Question of 10 marks, you use 25 minutes. Question of 5 marks, you use around 12 minutes. So this question was you are supposed to use that 8 minutes. You use 44 minutes. So you are out. You went beyond. So the legal opinion, Cliff and Alan advocates for may be first email Cliff for the telephone number. Our left, your ref, date. Of course, legal opinion, you do as you do. You have learned in your legal writing and drafting class, you do it like a letter, dear sirs, reference, your legal possession, and the way forward. The above matter following your instruction, we render our opinion as follows. Brief facts. I've said in the previous classes that you will minimize the brief facts because they are already given in the question, so that you have time to write other important things. You are charged with deferment contrary to Section 8 of the Sexual Offences Act. However, on cross-examination, we were discovered in the charge sheet that we are not amended. You are convicted on the amended charge sheet to deferment contrary to Section 3, assessed to 20 years imprisonment on mitigation. Issues. Whether the sentence was excessive, what step can take to remedy this, whether failure to take plea to the amendment's plea was prejudicial to you. So these are the legal issues which the examiner will be very more interested, and your analysis and the way forward. So analysis, the charge sheet for deferment was contrary to Section 3 of the Sexual Offences Act, which prescribes punishment for more than 15 years imprisonment. Act guide judicial officers, although they were mere excessive their discretion. So in the sentences, they cannot go beyond the prescribed sentences. In your case, you were sentenced to 20 years imprisonment over the prescribed maximum sentence of 15 years. It's our opinion that you have good and arguable cause of action. Section 214 of the Criminal Procedure Code gives you the court discretion to amend a charge sheet, a defective charge sheet, in either form or substance before the conviction of the accused. In this case, the court amended the charge sheet but failed to provide you with an opportunity to rebut or to re-examine or recall witness, which is very good. That's good analysis. It is our opinion that you have filed an application for revision within High Court under Articles 4750 of the Constitution, Kenya Section 362 and Criminal Procedure Code. So when you go to this question, what were the defects in the proceedings of this case? This person, of course, this is defilement because the children were less than 18 years. So the correct section was Section 8. One and 2 of the Sexual Offences Act. If you look at the Sexual Offences Act, a child of less than 11 years You are supposed to be charged with section 8(1). A child of between 12 and 15 years, you are supposed to be charged as a section 8(2). A child of between 16 and 18 years, the child, you are supposed to be charged under section 8(3). So if these children were between 15 and 16 years respectively, so the correct section to have charged this person was section 8(2) and 8(3). So the charge sheet was defective because of quoting the wrong particulars. That is what you are supposed to say. Are we together, Marian?
Yes, we are.
Then you say that when the magistrate was delivering the judgment, he quoted section 3. So he quoted the wrong section. Section 3 talks about rape, and rape is for people who are persons who are more than 18 years. And then the magistrate did not so he ought to those were the two defects in this question. The first question was the first defect was that the child they were charged with the wrong section of the Sexual Offences Act, and unilaterally amended the charge sheet and was sentenced on the wrong section of the law, which is section 3 of the Sexual Offences Act, Badalaya section 8(2) and 8(3). Are we together?
Yes, we are.
Then I told you that, and we discussed this in the last class, that every time the accused, the sentence is already given, you do a petition. A petition is better. But when the case is still ongoing and you want to appeal on anything, that is when you do a revision. So this question was testing on revision and on a petition of appeal. Not a revision. A revision is better when the case is still going on. But when you see that the case has already been delivered and the sentence given, that is a petition. Are we together?
Well, I'm not understanding because I also we discussed with Ruth there's the other question you had typed out.
Yes.
Is it I got it wrong. I did an appeal instead of a revision.
Which one?
Unless I go through it's in the previous draft book I had, but like this, it was one where we were seeking the magistrate, the ruling on producing defense evidence to give it to the prosecution. You remember?
Yes, that was supposed to be revision, eh? And did you attend that class?
No, I was not able to attend that class. But
and that's why I was telling you.
Yeah,
that's why I told you listen to the recording before you do this, because this is I wanted this question to build up on the last class. The one we did on Kenyatta, on Machujade.
Yes.
So every time, if you see it is an appeal on bail on something that is happening during when the case is not concluded, you do a revision. But if the sentence has already been given, that is, you do a petition. We discussed even this in the, I think, class number 2 or 3 there. You don't remember?
I do not. Okay, I think I've been confusing myself because but like in this question, I had thought section 215 of the CPC, it says that the court can amend the charge sheet anywhere before the conviction of the accused. And I thought in reading the question, the amendment had been done before the conviction of the accused. And then there was the issue of whether it was prejudicial for him because he was not allowed to take plea and cross-examine the witnesses again. And there's a case, I just cannot remember which one, that says it's not substantially unjust if you're not allowed to retake the plea, especially when the amendment is on a small issue or form.
Okay.
Not necessarily. So now in this case, that's why you see even I did it as a third issue, because I could see the examiner wanted us to mention it, but was not sure how to address it. Because it was an issue where we are just amending the section under which you're charged for. So I did not think it was substantive enough so that we do an appeal. And the major ground seen was the sentencing was for a period over the statute, the one given by statute. So I was thinking a revision would have been appropriate.
Your legal opinion is, to some extent, is good. Yes. Your legal opinion, you have tried to do the legal opinion, but every time, despite all the things that happened, when the sentence is given, is already given, the appropriate thing you do is a petition. All the other things are now going to be the grounds, or the grounds that the charge sheet was defective, what the wrong sentence. So anytime that the sentence is given in an exam, everything that is happening during the proceedings, the case that was going on, becomes the grounds. But if the sentence is given, you do a petition. But if the case has not ended completely, it is things that are happening here therein. For example, bail ruling, which is excessive. Someone was not able to be given time represented by an advocate. He was not able to table evidence. All those things. You do a revision. Are we together? So yes, when a sentence is given, it overrides everything else that was happening in the proceedings. You do a petition of appeal. And we had said that somewhere that during our one of the classes. Sawa.
Yes. So just for clarification, if it's before sentencing, that's when we do the revision.
Yes.
If it's after sentencing, we just go directly to appeal.
Yes, it is revision.
Okay.
Sawa. And you see the difference. There's a question in the year 2008 to 2019, where there is it's asking between the difference between revision and an appeal. So I've said there, not a revision is usually used when the case is still going on, and petition is where the case has been completed. Are we together?
Yes, we are. Yes, we are now. Now I've understood the difference. So it is the opposite of what I did. Okay.
Yes, it's opposite of what you did. So that is a trick there. And there is look at that question. Difference. What is the difference between the other differences between a revision, and an appeal? It is a question that was asked, and I have answered it. So,
Mwalimu,
petition of appeal, you don't have a problem so much doing. And I know you are going to do a good petition. So we can go to the next question. This is question
Mwalimu,
1A, November 2011. Same facts, but now working for DPP and wants to strike out the appeal for being filed out of time. Draft the appropriate pleadings. 15 marks. So this is a question that we are supposed to use around that 8 minutes. Question 1, we read the facts in the last class. I don't need to read the facts. The ruling of this magistrate was delivered on 20th January 2010. And when you are told to prepare the necessary instrument of in an exams, you date the instrument the day of the exams. We have already said that. So, and you file, of course, you file the same day. You draft and file the same day. Those are the presumptions. But you don't put the day the court is going to hear the application. You remember I told you that way because that is the work of the judiciary. But the exams presume that you file and you draft and file the same day for purposes of calculating the timelines. So the exams was done on November 15th, 2011, and the judgment was delivered on 20th January 2010. So that means, of course, they are out of time. A petition of appeal should be filed within how many days?
14 days.
Eh?
14 days.
14 days. So now the DPP has the power to, you can be asked this question. They can move to court for the petition of appeal to be struck out for being filed out of time. And that is the purposes of this question. Let's see your answer. So, you use 27 minutes, which was within time. That's good. Okay, before we go to question 2, there are some things you have written about question 1. Just to add, it is very, very important because in a criminal question, which you are going to do in the next 2 weeks, in a criminal paper, you be asked where someone has committed sexual offenses. And of course, you know that the sexual offenses are not found in the penal code. So you need to know these sexual offenses, the provisions, and the provisions and the sentence in your head you memorize, because you not have a penal code. And the relevant section are section 3, which is for rape, section 4 of the Sexual Offences Act 2006, attempted rape, sexual assault, defilement, which you have dealt with it in this question, attempt defilement, section 9, Gang rape, section 10. Then there is a case called Maingi and 5 others versus Director of Public Prosecution and another 2022. Maingi and 5 others versus Director of Public Prosecution and another, where Justice Odunga declared that the minimum mandatory provisions in the Sexual Offences Act are constitutional because they take the judicial power of listening to a case, mitigation. They tie the judiciary. So you can be asked to discuss the finding in that judgment. What was it? There's a question in criminal. They put a case law and they ask you to discuss. I think it was on in either April 2022 or November 2022. So you can be told to discuss this case. So it is very, very important to know what was the finding. Are we together?
Yes, we are.
Yeah, so look at that case. So we go to the question 2. DPP appeal to striking out an appeal. Of course, it's a notice of motion. The Republic of Kenya, High Court of Nairobi, criminal appeal number, Mwaika Aduma appellant versus Republic respondent. That is correct. Notice of motion. Take notice that this honorable court will be moved on the day of 2011 at 9 o'clock in the forenoon as soon thereafter, so that the State Council may be heard on the application for that the petition of appeal lodged on 22nd November, the day of the exams, which was 14th November 2027, be struck out. Which application is based on the following grounds? That the appeal lacks merit. I told you the grounds here are legal grounds. This is not one of the grounds. When it's application to strike out an appeal. And this, the grounds here is that the appellants appealed, filed a petition of appeal out of time without leave. Are we together?
Yes, we are.
And this applies both for civil litigation and criminal. Anytime you are told you draft an appeal out of time, an application to strike an appeal out of time, this can come in your civil litigation. We may not have time. Of course, we will not have time because after this, I want us to cover probate kidogo. Every time you are told to, and of course, this area has not been tested a lot in civil litigation and criminal, so it can come. So, so here you put the petition of appeal or John be struck out, the notice of appeal be struck out, depending on the question, which is application of, on the following grounds: that the petition of appeal was filed out of time without leave, because if you if the time prescribed by an act of parliament or the regulation is over, what you should do is for you to seek leave before you file the document. So that is the main ground. So here you amend. Which application is further upon the ground supporting affidavit and grounds adduced at the hearing hereof. And I told you in your previous drafting, if you're not sure about the legal grounds here, you can leave them. But of course, if you put them, you earn more marks. Dated at Nairobi, this day of 12th December 2011, supporting affidavit. I, Nyambura Jerry, resident of Kanyerere, Nairobi, Post Office of the Republic of Kenya, do hereby oath and says hereunder that I'm a man of sound mind and prosecution counsel in the matter that's competent to swear the affidavit. That the appellant was charged and convicted of offenses of theft contrary to section 281 of the Penal Code and sentenced to 16-year-old with 10 strokes by Honorable SRM and the Mimani Law Court. That the rendered magistrate followed due procedure in contracting trial convicting citizens that could be that the appeal has made it that the what is deponent. So number one, number two, in your affidavit is correct. Then you go now to the case. 3, 4 is not relevant. You say that the appellant having their case delivered on 20th January had 14 days to file an appeal. So the last day for filing an appeal was 14th February 2010. That the appellant filed the appeal without leave of court, and and they have not explained the delay. That the Criminal Procedure Code prescribes the time by which a petition of appeal should be filed. Then you quote the section. Then you say that this is which the appellant violated. That what is deponent hearing is to the best of my knowledge. Are we together?
Yes.
So that's how you do an affidavit. This also applies to civil litigation, criminal litigation. You say you state the timelines here, and there is a case here called Roslyn Miano and another versus Edward Kariuki Nyige and 50 others, 2015. Roslyn Miano and another versus Edward Kariuki Nyige and 50 others, 2015 EKRR. Those people moved to court for the court to strike out an petition of appeal. Of course, the section, I think 349, says that the court can extend time when the petition of appeal is filed at a time. So the court, instead of striking out an appeal, it extended the petition and deemed it for to have for it to be deemed as to have been filed. Of course, this means that you can also be asking a question acting for the appellant. Now you do your reply to a petition by DPP to an application by DPP to strike out an appeal. So that is a case that you can use well. And look at the case. It has very good analysis, even how you are supposed to draft this notice of motion and supporting affidavit. Yes, are we together?
Yes, we are, Mwalimu.
So, now I want us to go to the last question of the day, which we are going to spend some time on it. But before that, I want you to, in your preparation for your class, I've told you that you practice on how to draft an application to strike after an appeal for being filed out of time. This can be an application whether in the Supreme Court, in the Court of Appeal, in the High Court, both in criminal and civil matters. That is an area that have not been tested. So look at the timelines that are need, because for you to file an application out of time, you know, to have the timelines ought to have been violated. And an application also to file appeal out of time, both criminal and civil, whether in Supreme Court. Of course, Supreme Court, we are going to deal with it a little bit. We are going to deal with it now. Court of Appeal, an appeal to file out of time, get a case law, appeal to file out of time in civil cases, in High Court, all these things. All these applications are done through a notice of motion. Look at the case laws. Look at how the parties have argued in court, and that's how you are going to do a notice of motions at the supporting affidavit. These are an area that have not been tested much in both criminal and civil. And I'm suspecting one or two questions will come on this area, both in either in criminal or civil. And because we will not have time for civil, kindly look at it. Are we together?
Yes, we are.
So now we go to the last question of the day. This is on the Supreme Court, appeal to the Supreme Court. Both in criminal, we are going to cover criminal and civil litigation. This is an area that have never been tested. And because Supreme Court here with us, it's just a matter of time before they test on this question. So I found it to be very, very important that we test. I teach you on this area well. So before we look at the question that I gave you, appeals to the Supreme Court, of course, from the Court of Appeal, are found in Article 163 of your Constitution. That is a basic thing you need to know. 163(4) of the Constitution, Article 163(4) of the Constitution, appeals. There are two ways appeals go to the Supreme Court. Have you covered this area in your class?
In civil, yes.
Yeah.
In criminal, no.
Yes. So let me, of course, let me now build your knowledge on if you have read in civil and criminal. It's just almost the same. Let me just build on your knowledge on the same area, because I suspect is very examinable. So Article 4A, when as of right, in any case involving interpretation of the Constitution, you can appeal to the Supreme Court. And we are going to deal with the timelines right now. I'm going to open the Supreme Court Act. And then the other way is through certification. So a right of appeal. So if you think that the issue at the Court of Appeal was involving the interpretation of the Constitution, you appeal directly to the Supreme Court within the timelines given, which I'm going to tell you in a minute. But of course, when you go to the Supreme Court and you have filed your case, one of the questions, the first sitting of the Supreme Court, they usually sit and decide whether indeed your case involves interpretation of the Constitution. So they have that determination first before they hear. And there are several cases online on the same. So the other way is through the certification. So if is a public importance, general public importance case, now you need leave from the Court of Appeal to apply, and that is Article 163.5. The Court of Appeal need to certify to give you permission to appeal to the Supreme Court. That is Article 4B and 5. Then your certification by the Court of Appeal may be reviewed, varied. So if you are declined certification by the Court of Appeal, you can appeal to the Supreme Court. If the Court of Appeal allows you to go to the Supreme Court, certify that the matter is of general public importance, that certification can also be reviewed, can be declined by the Supreme Court. So it is a two stage. That is section, that is Article 4, 163.5 and Article 163.6 of the Constitution. Are we together to that point?
Yes, we are. I had a question.
Yes.
The article talks about the matter being certified by the High Court. I mean, by the Court of Appeal.
Yes.
What is certification?
Certification means giving permission. That's what it means. If the Court of Appeal, after the appeal is given, after the appeal is given, you need to go back. If you lose an appeal in the Court of Appeal, you can go to the Court of Appeal and tell them, give me permission to appeal to the Supreme Court, because I think this question, this case needs the attention of the Supreme Court, because it's a matter of general public importance. So the Court of Appeal, even if it has dismissed your appeal, it can give you the certification. Are you getting? Then
yes,
yes.
My follow-up question is, in the exam, should we draft the application for leave to the Court of Appeal?
This is what I asked in this question.
Oh, okay. Okay.
This is what the question was asking, eh?
Yes.
This is what the question was testing, and we are going to reach there. Then after, if this certification is given, that is not automatic. The Court of Appeal also has a say on it. So you can be given permission by the Court of Appeal and the Supreme Court declines to allow you to appeal. Or you can be declined by the Court of Appeal and you appeal to the Supreme Court. That is what is called certification by the Supreme Court. And it allows you to appeal to it based on general public importance. Are we together?
Yes.
So now I'm open the Supreme Court Act. We now look at the regulation therein, and we look at the Supreme Court Act first. Then we look at the regulations, relevant regulation for purposes of exams, both in civil and criminal. We look at some case law, and we finish with the exams, the mock question that I gave you. So you can open your Supreme Court Act. And we look at it. Now I'm sharing the screen for Supreme Court Act. We look at various sections. We start with section 15. This can come also as a theory question, both in criminal and civil litigation. They can come as a drafting question. That's why I thought we deal with it substantively, because all this what I'm saying here will help you in answering the question. I hope you can see the screen. You can see it?
Yes, I can.
So this is Supreme Court Act 2020. No, Supreme Court Act. It was not for 2020. Supreme Court rules are there for 2020. Supreme Court Act was, of course, it was after the Supreme Court was enacted. That is Supreme Court Act of 2011. They did the regulation later, but all were repealed. So the regulation that are existing now are for 2020, but the Supreme Court Act is for 2020 to 2011. Of course, the Supreme Court hears the presidential petitions, advisory opinions. If a judge, a tribunal hearings, the main purpose for Supreme Court are presidential petition, presidential elections. That's what many people know it for. Hearing, giving advisory opinion to county governments, you can look at Article 163. Exclusive original on presidential, then apparent jurisdiction from the Court of Appeal, which we are now going to deal with it. Then advisory opinions from any national or county request. That is Article 163.6 from national or state organ. Then if a judge has been found, the finding of a tribunal misconduct from a judge, you, after the finding of the tribunal, you appeal directly to the Supreme Court, and the Supreme Court has had so many cases since its session in 2011. Whatever case, they dismiss the finding of the tribunal on misconduct. On Martin Muya case, a judge, they found that the tribunal to have found him not to have been removed him out of office, so they reinstated him. So that can be asked even in professional ethics. Yes. So section 15 of the Supreme Court, what we have just said, shall be heard only in leave of the court. Then appeal as right, Article 163 4A. So when there is on interpretation of the Constitution, but I've said after you file the petition, the court usually makes a determination whether indeed the question, your petition raises constitutional issues before they hear. So this section 15B, we have already dealt with it. An appeal to the Supreme Court, a matter of general public purpose, shall only be made upon certification by Court of Appeal, then upon certification by Supreme Court. So it's a two thresholds, two tier. An application for certification shall be filed before and determined by Court of Appeal in the first instance. So that's one. Then direct appeals from tribunals, judge, a finding under Article 168 on misconduct, a tribunal to remove a judge from office. That one you have dealt. That is Article 15C. Then you go now to 21A. Supreme Court has power to review its own decision, either on its own motion or application by any party. So Supreme Court is not bound by its own decision. It can be reviewed either by motion moved by any party or its own motion. That is very, very relevant. 23A, it can stay proceedings. Stay of proceedings, injunction, conservatory orders, upon certification, if the case was still pending in the court, in the Court of Appeal, and there was something happening. So what is conservatory orders, Marianne?
They're like what are they called? They're like to ensure the status quo. That's what I was looking for.
What is the difference between an injunction and conservatory orders?
The difference is you can injunct like private individuals. You cannot injunct government or government agencies. So that's why we use conservatory orders against them.
So that is a very good difference to know. Many students don't know that. Intercalatory, the orders, judgment of the court, it is by majority. You usually see how they say they sit at this. Any five can sit to hear a case. This is the majority. Delivery, contempt of court. You can how do you in contempt of court? So those are the relevant section. You can look at the Supreme Court Act, at it. At the end, afterwards, for further, but for purposes of civil litigation and criminal, I think those are the most relevant section. So now we go to the Supreme Court rules of 2020, which are very, very important. We are going to start with Rule 33. I don't think they can ask you in an exam. I don't think they can ask you on presidential petitions. What they can ask you is on the normal civil, which I want us to deal with. So I'm on Supreme Court Rules 2020. registrar maintenance of registry. You can look at the rules later. But for purposes of this class and the exams, you look at section 33, which talks about application for certification. An application for satisfaction must be in the first instance be made in the court which made the appeal originates. We have already said that when the court of appeal has certified or declined to certify a matter, aggrieved party may appeal the court for review within 14 days. So that's the first timeline. When the court of appeal has declined the matter of as general importance, and aggrieved party may apply to the Supreme Court for review within 14 days. So that is the most important thing. And the application under this rule is an originating notice of origination notice of motion. Notice motion set in Form E. Form E is here down. So we can look at it how it is it's look like. Form E. Originating motion is this one. You can see how it look like. Applicant, respondent. Let originating notice of motion. Let all parties. So these answers some of the question I asked you. So you do the let dash of this within the after submission of the application we claim nature. So it is an originating notice of motion. So that is how you apply to the Supreme Court for review. If you it refuses to give you certification. And this is a question that can come. Are we together?
Yes, we are.
So note that one. Upon filing of the application under rule, the applicant shall serve the application within 7 days. All responses shall be filed within 14 days. Upon service, any response within rejoinder within 7 days. So that is important there. Then there is non-attendance of hearing, abatement of application, notice of appeal. The next most important thing. A person who intends to make an appeal to the court shall file a notice of appeal. So you start with a notice of appeal. If certification has been given, you don't if certification has been given, all the question is a petition of appeal. So it's of general public importance. So if it is a case of interpretation of the Constitution, you start with the notice of appeal, which is within 14 days from date of judgment. Then you file the petition of appeal, which we are going to look. So we start with notice of appeal. And you see, Rule 36(4) says, notice of appeal shall be in Form F. So the notice of appeal which start a case at the Supreme Court is in Form F. In lodging an appeal on the matter of general public, it shall be mandatory to obtain such certification before filing a notice of appeal. So You start by certification, if it is a matter of general public importance. Then after you are given leave by either the Court of Appeal and which have also been which had been given by the Court of Appeal, or if it is declined and it had been given by the Supreme Court, which of course you had, we said here, if it is declined by the Court of Appeal, you have 14 days to appeal to the Supreme Court on certification which has been valid. After the certification have been given either by the Court of Appeal or Supreme Court, you have 14 days to file a notice of appeal. But if it is a case of raising interpretation of a constitution of which was of a right, is a right which does not need a certification, you need a notice of appeal, which needs to be filed within 14 days after the date of judgment, if it is a court of appeal, in the interpretation, or after the certification. And the form is in Form F. Form F is here. Form F is here. Form F is here. Is the normal notice of appeal, how it's done. Take notice, blah, blah. This person being dissatisfied with the decision given on this intends to appeal to the Supreme against the whole decision of the same decision and decided the address of parent is the intended to serve service of petition to the notice of, then date you date the registrar of the Supreme Court wrote in. So that is how the notice of appeal should look like. Are we together, Marianne, up to that point?
We are together. The only thing I'm very confused on is how the application for certification looks like.
We are going to deal with it.
Okay.
Yes, it's an originating notice of motion in the Court of Appeal. In the Supreme Court. So you have to look at it here, E. It is this one.
Yes.
It is this one here.
Oh, it's that one.
At the Supreme Court is this one. Let me show you. It's Form E, this one. Are you getting?
Yes, I'm getting it now.
Originating notice of motion. Let all parties. That's how you start. You know how you do the other originating motion?
Yes.
So we are going to look at one of the case law that was valid, that was reviewed by the Supreme Court.
Yes.
And we are going to see the motion they used there. So, and then we are going also to, for the Court of Appeal, the application used is the notice of motion. It is in the Court of Appeal, the Court of Appeal rules, but this is the motion, notice of motion in the Supreme Court, which, because this is the Supreme Court rules. But for the certification in the Court of Appeal is in the Court of Appeals 2022, and we are going to look at it just in a moment.
Yes, Molly.
I want us to go procedurally so that we deal with this question once and for all. Then, of course, we have dealt with Section 36. We have dealt with the notice of appeal, service, the time you need to serve. You need to look at that. So then, the other very, very important rule is that Rule 38. After you have filed your notice of appeal, Then you go to the petition of appeal. Rule 38 is very, very important. An appeal to the court shall be filed within 30 days from date of filing a notice of appeal when the appeal is of right. So then 30 days after grant of certification, where such certification is required. So what this rule says is that after you file your notice of appeal, we said here you file within 14 days after the decision of the Court of Appeal, if it is a matter of right, or after the certification is given, then you have 30 days to file your petition of appeal. After the notice of appeal is given, if the appeal is of right, then 30 days after the grant of certification. So this that means you don't need a notice of appeal if the certification is given. So there is a conflict between section 36(1)(4). In urging an appeal of a matter of general, it shall be matter they are saying here appeal before filing notice of appeal. So they have said 30 days after grant of certification when such certification is required. So there is a conflict between 36(4) and 36(1)(b). But for purposes of exam, know that it is notice of appeal. Then 30 days after the notice of appeal, you file a petition of appeal and the record of appeal. Petition of appeal, of course, contains everything, and it is in Form G. Here, we are looking at Section 39, Rule 39, petition of appeal. It's look like that. G, in the Supreme Court of Kenya, petition number between petitioner and the respondent, then you put here is in appeal of judgment of ruling of the Court of Appeal delivered by this judge on this day, in this case number. The humble petition is as follows. Then you put the petition is a petition, points of law, summary grounds of appeal, argument, the question for determination of this court, dated and signed. Then, of course, you put the, that is a petition. They don't talk about us this supporting affidavit. That one we are going to check right now. So that is how you look you do a petition. Are we together, Marianne?
Yes, we are. We are very together.
So all this knowledge is very, very important. Those timelines. Then we go to the Court of Appeal rules. We look at the certification by the Court of Appeal as a matter raising of public interest, as raising matters of public interest. And the relevant rule is 41(2). The screen is sharing. Let it share. I can be reading. This is rule 40 as the screen shares. Rule 41 and rule 42. More importantly is rule 42 is the most important. Rule 41 too. An application seeking certification that a matter for general public importance involved shall be made within 30 days of delivery of the decision. So you have 30 days in the Court of Appeal to seek certification. Of course, you can seek leave to appeal out of time. If 30 days have gone, and it's done with by either a notice of motion or a chamber summons, and but most likely the chamber summon is usually done. There is a case that the Court of Appeal just the other day allowed this girl, the Miss Rangata, who killed his husband. Of course, the Court of Appeal decision was delivered kitambo. So he applied just the other day through Professor Gedo Muigai on certification. It was Kamande versus Republic. He was allowed to appeal to the Supreme Court as a matter of general public importance. Of course, it was it's one of the cases worth looking at. You can use it as an example in this area, in criminal case. Criminal application 102 of 2008. I just want us to look at few cases on this area for better understanding. Then we look at the the drafting that we did, that Marianne did. This area, Supreme Court area. So I just want us to look at this area case for better understanding of this area. I'm opening the case. So, of course, these certification cases are many online, both in criminal and civil, and the review that has been banned by the Supreme Court. There are many cases. A student needs to get several cases to look at them for purposes of the exams. So the screen is loading. Marianne, you can open Commander versus Republic, Criminal Appeal Application 102 of 2018. Commander versus Republic. Sorry?
While we're discussing that,
yes.
So just for clarification, the Form E is when the court itself is doing the certification.
Yes, Form E.
The Form E we had seen is whereby, yes.
Form E. Form E is when you want a certification by the Supreme Court. Form E, generally, Form E is when you want the decision of the Court of Appeal disallowing you to be valid. You see, there are, when the certification is given by the Court of Appeal, most of the time is when it is declined, you can appeal to the to the Supreme Court through Form E. Are we together?
Yes, we are together.
Most of the time is when you have been declined the certification by the Court of Appeal, then you appeal to the Supreme Court. We are going to look at one of the case here. There is a case, we are going to look at it. So the case that is showing on the screen, this is certification. This happened just the other day, 6th October, 3 weeks ago. Miss Rangata. Of course, the judgment was delivered 6th November 2020. So, of course, he sought by leave of appeal. So, as we have said, it is a notice of motion because the case is still there. Ruth commanded by the respondent, being an application for certification leave to appeal to the the judgment of Court of Appeal of Kwengu Asame JA dated 6 November 2020 in Nairobi Criminal Appeal. Then is a notice of motion applicant leave. So if it is a matter of general public importance, you need to say why. Of course, the notice of motion, you say, you quote the Article 163(4)(b), and they say that you need leave to appeal to the Supreme Court as a matter of general public importance. Then in your grounds of application, you need to state the grounds. And the grounds why the court can give you a right to apply on matter of general public importance are there. Is where the determination which transcends the circumstances of particular case, which are bearing the public interest. So that is one of the grounds. Where the matter in respect with certificate is sought, this is a point of law, and the matter is substantial one. So by giving leave, general importance, the Supreme Court will be dealing with the question of law. So the Supreme Court have pronounced itself the meaning of matter of general public importance. A matter of general public importance, warranting the exercise of the appellate jurisdiction will be a matter of law or fact, provided only that its impact and the consequences are substantial, broadly based, transcending the litigation interest of the parties is beyond the litigation interest of the parties and bearing upon the public interest. So that is the grounds, legal grounds. So the principles set out in Hamas, Phillips, and this case. A point of law, a substantial one, there is uncertainty of law, so are you getting the grounds?
Come again, Mwalimu.
Are you getting the grounds? The grounds?
Yes, I'm seeing them.
You can see, you can look at this case. So this case was allowed because they said that, you know, this lady was battered so many times by the husband, and he developed a syndrome. So they are saying that in matters where women have really gotten this, have been battered by their husband, and then they need to defend themselves. So if you look, the applicant has substantiated in this, but it's a novel issue of law that requires Supreme Court to pronounce itself on the standard of burden of proof to guide other courts. It's strictly that criminal proceedings, the standard of proof is beyond reasonable doubt, and burden of proof rests with the prosecution. In her appeal to the Supreme Court, the applicant seeks to converse the proposition that once the defense of self-defense is adduced, as circumstantial evidence is read to the effect, the accused ought to enjoy the benefit of law. So self-defense is matters of women who have were battered. The issue of surrounding battered women syndrome is ideally low in the country. So these are questions that's public importance. These women who are battered by their husband, and one day they wake up because of the provocation, they revenge. So that is why the Supreme Court, the Court of Appeal gave the certification. Are we together?
Yes, we are.
So it was allowed. It was allowed. So we await the Supreme Court decision on the same. It's another case here. Although this is civil, I want us to look. Now this is certification, review of certification by the Supreme Court. It was delivered just the other day. It is just want us to look at it to have an idea. I can hear she. What is the issue?
I'm sorry. My aunt. I live with my aunt, and she's also in her master's class. Yeah, that's probably who you're hearing in the background.
No, I'm just hearing brrr, brrr. So these are just another case that was delivered just the other day. You can hear me, Miriam?
Very well, Mwalimu.
So this is just another case that was delivered just the other day, 6th October, by the Supreme Court. It is a civil case, but you see there is no difference between application for review both in civil and criminal. So it will survive even for criminal. Of course, there are criminal cases where people have sought certification, but I did not have time to look at it. I just so if you see this case, of course, if you look at what we said there, Form E, you said use applicant and respondent. This applicant respondent being an application for review or decision of Court of Appeal delivered on denied certification. So June 9. So they are out of time. So they went through the provision of where you seek leave. So motion dated filed on section this, and this. We have looked at it. Review of the ruling. One involving matter of general certification intended. that leave to amend the notice of appeal dated to replace upon ground on face of the application affidavit. So you swear an affidavit also, we said that. You can look at the decision of the Court of Appeal, which declined for no knowledge, and the motion was dismissed by the Court of Appeal, by the Supreme Court. And the courts of application, they were not allowed. But of course, there are instances where they are allowed. It was not allowed by the Supreme Court. There are instances where the certification have been denied by the Court of Appeal, and it has been allowed by the Supreme Court. I have one case here, criminal. In fact, this is the basis of this, the question that I sent. The facts were here. These people were Iranian. They were arrested for having been terrorist acts. So they were convicted, I think, by the magistrate court. They appealed by the High Court. The sentence was valid in the High Court. The Court of Appeal released them. Then the state applied for certification in the Court of Appeal. The Court of Appeal declined, and after the Court of Appeal, the state sought an application in the Supreme Court, which certification was allowed to appeal. And the final judgment of the Court of Appeal affirmed, I think, the magistrate finding. So they were convicted, and after the conviction, they were supposed to be repatriated back to Iran. So the question that I want us, the Nini I want us to, the one that now I'm opening is the certification, the decision of the Supreme Court allowing the allowing the denial of the certification by the Court of Appeal.
You actually gave us that question. I don't remember which, because I think, is it question 4?
It is a question now we are discussing, eh?
Yes.
Yes, is the question. This is a question. In fact, I got the facts here. I just validated the facts here.
Just a follow-up.
Yes.
When you are seeking a revision by the Supreme Court, do you need certification as well? Because this wording hapo kwa article 163.
You when you are review, it's a review of the Court of Appeal decision, eh?
Yes.
Which after they allow the decision of the Court of Appeal declining, eh? It's now become the certification of the Supreme Court. Unaona?
So we need certification bado.
The certification is done by the Court of Appeal, eh?
Yes.
If the Court of Appeal declines, you appeal to the Supreme Court with what we have said there, originating notice of motion, eh?
Yes.
And the Supreme Court can vary, can do two things. Either certify, allows. That is what it means. It is certified, allows. Unaona? If the decision by the Court of Appeal was declined, unaona? Or it can uphold the Court of Appeal decision declining you the certification. Are we together?
Yes.
So that is an inibato. Your background is there is yes. So this is a Court of Appeal final decision. What it says. So all these cases you are seeing here are from the High Court. Of course, Kenya will report they report the decision from the High Court. So it had started in the Magistrate Court, appeal to the High Court, Court of Appeal, then Supreme Court. And yeah, that is a very good criminal case dealing with all these things. So I think this is a case that I'm opening. So yes, this is a case. No, this is not the case. This is a Court of Appeal. I'm looking at the Supreme Court case. There is a Supreme Court case which they allowed of course, they are first of all, of course, this is a Court of Appeal denying the certification. Yeah, this is a Court of Appeal denying the certification after these people are released by the Court of Appeal. Then the state appealed. As you can see here down, the court is saying we have said enough. We believe that the most application for the firstly for want of view, and secondly because the applicant has not met the threshold for certification. So the state appealed, and it was allowed. It is Republic versus Ahmed Abudi Fadi Mohammed and another 2018. You can look at it. During your time, you can do a good search here and you see how it was allowed. Because of time, I want us to go to your question back. Of course, we have dealt with many things on we have dealt with the question substantially. So these are the facts of the case, which I not need to read. You work for DPP, aggrieved by the decision of the state wishes to make an application to allowed it to the Court of Appeal. So we have said that the application is a notice of motion, and you say general public importance, as you say the facts that we have said in Kamande case. You don't do the for certification. You don't do this way. It's when that as a certification is given, you now file the notice of appeal, and you have said the timelines. Then DPP, then the Supreme Court. If it is the certification by Court of Appeal is denied, you can appeal to the Supreme Court, originating notice of motion. You say the same things that you said in the Court of Appeal. Yeah, that's how it should be done. Are we together, Marianne?
Yes, we're together.
We are together. Let me see. Let me try to look at this case, that the remaining minutes that are there. You can help me find it. This case of Republic versus this guy Ahmed Abdullahi Mohammed and another 2018. The certification, which valid the denial of certification by the Court of Appeal. Of course, allowing now the state to appeal to the Supreme Court. Criminal appeal application, not this one, because the petition of appeal was delivered 19. Let's see. This was delivered on the Court of Appeal denial certification delivered on 16th February 2018. So it is after this. Let's see this one. Spring a database error. I think it is this one, 28th April 2018. I hope it's not going to bring a database error. This area is an area that is very, very important. In civil and criminal, it can come as a theory question or as a criminal question, as a theory question or a drafting question, either in civil litigation or criminal. So you need Yes, this is it. Republic versus Ahmed Abdulvadi Mohammed and another. So, as we said, is the applicant and the respondent being an application for the review of the decision of Court of Appeal, 16 February. Dispute the applicant certification. You can see.
You're not.
Sorry?
Yeah.
You can see.
You're not projecting it. I'm still seeing the questions.
Oh. So, this is it. Of course, the denial of certification by the Court of Appeal was 16 February 2018. Then they moved very fast. The state moved very fast. The Republic and appeal the denial of certification. And participant can now see for review of the decision of the Court of Appeal. So it gives the background. It gives the background, what happened. You can read. So the state review and set aside of the decision, then grant leave. So these are the grounds you can put in your application. Of course, so in your notice of motion say that the applicant be allowed to, that the court be vary the Court of Appeal decision denying the applicant from appealing to this court. So the second ground is that the Supreme Court certifies this decision as raising matters of general public importance and allow it to be appealed to the Supreme Court. So those are the two prayers in your notice of motion, originating notice of motion. So, and you can add these 5 grounds: that the applicant has an arguable appeal of high chances of success, that the intended appeal involves a matter of general public importance, the net judgment is criminal, then the intended appeal has significant bearing on public interest, what we said. In respect of this, the intended appeal will be rendered nugatory if stay. So you can put in this on the legal grounds. Then there is the supporting affidavit to give the story, and the Supreme Court I look at it and they allowed the certification. So this is a very good case. Are we together, Marianne?
Yes, we are.
So I want us to stop there.